Let me go to Chris Dimakos, our CJD 800 legal contributor. So, Chris, interesting situation today. So, let's talk about this. They said a recent judgment basically providing a warning to employers who hire employees with something called a two-step process. So, I'm going to ask you to describe what a two-step process is and what this really entailed.
Right. It's pretty common. If you are an employee, you're looking for a job. There are multiple occasions where you speak with the company. They send you an email telling you what your salary is, giving you a brief description of what the job is. You confirm, and then once you start working there, they put before you a much more formal contract with additional language, additional responsibilities, something that is a 5 or 6 pager that you didn't have when you agreed to it. And the reason why companies do that is they don't like to divulge sometimes all the inner workings of how their company works in terms of sales or whatever the position is. So they try to keep as much as they can private. So they try to reel you in by having that first email with the basic salary and the basic conditions confirmed, and then they try to slip in this second, more thorough contract at a later date. So what happened with this judgment was a woman was hired on an email. She agreed to the salary, agreed to the job title. She starts working. Within the first couple of days, she's presented with a much more formal contract with a lot more language and conditions. She signs that. A few years later, she ends up getting terminated because she violated some of the language that was in that second document that wasn't present on the first one. And what the court said was, no, you can't do that. That's an illegal termination because you didn't present that to her when she agreed to take the job. And when you gave her this additional language and the additional conditions, well, you never gave her consideration for that. You never paid her more for it. You never gave her some sort of incentive to sign off on that. All you did was make her give concessions. So what the lesson is here is be careful when you are looking to join a new company. Make sure that whenever you're signing off on it, that's the final document. You don't, ask questions. You don't want to just basically sign off on an email or a verbal agreement and then be faced with having a completely much more formal document that requires much more out of you than you originally thought. It's very important. Companies more and more now are going to have to start including everything at the get-go and not try to do this two-step process where they get you on board and then present you with the much more formal contract.
Yeah, you're discussing something or outlining something there that seems to me like a classic bait and switch, almost in a sense, right?
It is, and it's not so. I think what the companies, the reason why they do it is they want to hire the right candidates, and they don't want to run the risk of sending you a formal contract that details how commissions are paid, that details what their policy is and what their severance is, and all these benefits without getting the employee to confirm that they're gonna come on board, right? So it's kind of like they want their cake and eating it too. They want to be able to protect as much sensitive information as they can. The problem with that is that you're doing so at the expense of the employee. You're taking the risk of having somebody come on board that might have not come on board had they had the
Right.
full picture. So more and more we're seeing case law that's saying, hey, when you hire somebody, you got to give them the full scope of what they're signing on for. And if you're going to try to add some stuff to their plate afterwards, make sure that you compensate them for it, because if you don't, you run the risk of it becoming ineffective, right? So in this case, they used that language to terminate. It was deemed ineffective and it didn't govern that relationship, so it was thrown out. And this individual got paid a lot more money because that clause was deemed inoperable. It wasn't effective.
By the way, this goes to something we often talk about, which is this whole idea of, before you sign anything, get some legal advice. But in this case, your first offer, even if it's written, right, you can take it and have it legally looked at and it looks fine. It's when you sign that second offer, maybe before you do that, that's the one you should be taking to have checked.
Right, and I think the best advice I can give is if you are when you are going through the interview process, ask a lot of questions about what the process is like after you say, okay, I'm in. I'm signing off on this. What happens next? Is there any other documents I got to sign? Is there any other group plans that I'm going to be a part of? Any type of deductions to my salary that I'm going to have? You want to know as much as you can about the job after you sign off. And sometimes companies will say, well, yeah, there's going to be a more formal document you're going to have to sign. Well, ask for that up front. Say, can I have that, please? I'd like to see that before I sign off on this employment position. So ask the questions, ask as many questions as you can beforehand, so you know exactly what you're signing on for. Because sometimes, the worst thing is if you're employed with a company and you're considering leaving one job for the next, and then you do so only to find out that, oh, this is not as good as I thought it was, because they presented you with all this additional stuff afterwards. So you want to have as much information as you can in terms of what the job is going to be like and what your obligations are going to be beforehand, before you sign off on that, because you don't want to leave a job that you're okay with to go somewhere with the unknown of taking that risk and maybe conceding what you had at your previous job.
Yeah, and to your point, right, a ruling here. So someone took this to court and a judge agreed. So obviously there's a precedent set here now.
Absolutely. So in this case, it worked out for the employee, even though she signed it. She didn't get legal advice at the time. She signed it. It actually worked out for her in the end, because it's the employer that actually made the mistake. But you don't want to take that chance. You don't want to say to yourself, well, I'm probably going to have this thrown out anyway, so I'll go ahead and sign this without getting it looked at. You definitely want to make sure you get as much advice as possible. And again, transparency, be transparent. Ask them as many questions as you can so you understand what you're getting yourself into.
Chris Dimakos, our CJAD 800 legal contributor. Thank you, Chris.
Thanks, Aaron.